Hello folks, welcome to the Edupedia world, and I am Abhinay Gupta. Today we'll start a fresh new topic, which is the meeting of board and its power. Today we'll understand the function of the board in totality. How are the meetings conducted? What are the powers which is entrusted upon the board as per the provisions of the Act, as per the article, or as per any agreement, right? So, this topic would be supported by Chapter 12 of the Companies Act 2013, consisting of sections 177 to 173 to 195, and the Companies Meeting of Board and its Power Rules 2014. So basically you will have to refer to two things. One is Chapter 12, section 173 to 175, and the other are the rules supporting them, which is the Companies Meeting of Board and its Power Rule 2014. Right? Start with this chapter. First and the foremost thing that we need to understand is what is the meaning of board meeting. What do we actually mean when we say we are going to conduct a board meeting? Right? So board meeting basically is the meeting between the members of the board. And who are the members of the board? The directors of the company. May it be any director, additional, alternate, independent, executive, non-executive, any director, right? When this director meet, right, that is known as the board meeting. Now when we talk about meeting basically means the coming together of two or more persons face to face. But face to face does not imply that they have to come face to face physically, right? They could be face to face via video conferencing or any other audio visual means as well. And this is the amendment. This is the requirements of the new act. If you refer to your previous act, the 1956 act, you did not have these provisions, right? Because that act was made in the year 1956, right? And that time you did not have any concept of video conferencing or audio visual means or something like that, right? So the meeting of board, meeting means two persons coming face to face. But again, there's one thing that should be kept in mind, that there must be an intention to meet. And the accidental meeting of the director against the will of the other will not constitute a valid meeting, right? So that means just two persons sitting in front of each other and discussing something does not amount to board meeting, right? Board meeting has a procedure. It has to be called by that procedure, and then the date, place and time has to be fixed, and then the directors will come, they'll sit, they'll decide, and then they'll take the meeting forward. There are other requirements like the quorum and stuff, right? So there is a procedure that has been defined, right, between section 173 to 195, and the provisions which are related to board meetings are contained in basically three sections: section 173, 174 and 175 of the Companies Act 2013, right? And there may be some additional provisions contained in the article of the company, and that shall also be complied with. So to start in today's lecture, we would be covering section 173 in totality. That would include 173 subsection 1 and 5 that are dealing with the minimum number of board meetings. Section 173 subsection 3 that will deal with the notice of a board meeting. Section 173 subsection 2 also deals with other procedure of how the meeting is conducted. And section 173 subsection 4 will deal with the penalty. So let us start with the sections. First section that we'll be understanding in detail is section 173 subsection 1, the minimum number of meetings to be conducted in a year. So section 173 makes it obligatory for every company to hold a minimum number of board meetings, right? So this section defines the minimum number of board meetings that a company should hold, and that is an obligation, right? It says that the board meeting should be held at regular interval, and that there should be a minimum number. Right? Now, why are the board meetings held? They're basically held to monitor the conduct of the business, to regularly meet, and the progress is to be analyzed, and so that the board is well informed of what is going on in the company. Right? So that is why the boards, they meet. And the first meeting of the board should be conducted within 30 days of the incorporation of the company. So if 1st March is the day when the company gets incorporated, then before 30th of the March, anytime within that period, the board shall meet, right? Then that is about the first board meeting. There has to be a minimum of 4 board meetings each year. And when we talk about each year, we are talking about each calendar year. And calendar year starts from January and ends in December. So any company will have to hold at least 4 board meetings in each calendar year. Right? And then the other requirement is that the intervening period between 2 board meetings should not exceed 120 days. That means a gap between 2 consecutive board meetings shall not be more than 120 days. And 120 days is somewhere around 4 months. That means that a company cannot hold board meeting in the sequence. First is held in January, second in February, third in November and fourth in December. No. You will have to hold one board meeting within the next 4 months. Right? So if you are holding the second board meeting in February, the next board meeting should be held within the next 4 months. That is within March, April, May and June. And then suppose you have held the third board meeting in the month of June, then you have to hold another board meeting within the next 4 months, July, August, September and October. And then you have 2 more months left. But you have fulfilled the minimum requirement, so there is no obligation to conduct another board meeting in the month of November and December. But if suppose you hold the other board meeting in the month of October, the fourth board in the month of August, then September, October, November, December are 4 months. And you cannot give a gap of more than 4 months. So you will have to hold the 5th board meeting somewhere around November. Right? So that is how you look into this section. So is it a valid opinion, what we have just discussed? The last board meeting is in the month of November? The answer is no. Right? The only reason why we have discussed this example is to make the provision very clear in mind. There is no requirement of the fifth board meeting in the month of November, because as the provision says, the intervening period between 2 board meetings should be a maximum of 120 days. It does not say that within every 120 days you have to hold a board meeting. No. If you have to hold 4 board meetings, you can hold 4 board meetings in the month of January itself. Because you fulfill both the conditions, that is, you have held minimum of 4 board meetings in the calendar year. And the second provision, that the gap between the 2 is not exceeding 120 days. That is the only requirement of the section. That does not mean that you will have to hold another board meeting within the next 4 months and next 4 months and next 4 months. Right? Now I hope the provision is clear with you. And in the Companies Act, there is no requirement of holding at least 1 board meeting in every quarter of the year. It is not so. Just 4 board meetings throughout the year, whenever you want, you can hold them. Right? Now, central government is empowered to give certain exemptions to the company. The exemption from holding the board meetings. Right? So, who would be given this exemption? So, this exemption can be given to any company or class of company. Right? And this will be given by issuing a notification in the official gazette only. Right? So, the CG may issue a notification in the official gazette, and thereby it may refer a class of company and then give them an exemption from a provision of either holding the first board meeting or the minimum 4 board meetings, or may also modify this provision. It is not just necessary it would give a blank exemption, it could even modify the provision of the Act. Right? That means section 173 subsection 1 would apply to those companies subject to such exceptions, modifications or conditions as the CG may specify in the notification that is given in the official gazette. Right? Right? So I hope the provisions of section 173 subsection 1 is clear with you. And there is a little more from this section that is remaining, which deals with the 1-person company and the other companies. We'll discuss it while we are discussing section 173 subsection 5. Right? So as we are going in serial order, let us move to section 173 subsection 2. Right? So over here, in this section we would deal with the provisions of holding or conducting the board meeting through electronic mode or video conferencing. Right? So this is a new section, the new provision inserted by Companies Act 2013. We had no such provisions in Companies Act 1956 because of the time when the Act was framed. There was no concept of video conferencing back in 1956. Right? But as per the latest technological advancements, we know that it is a requirement. It is not possible for all the directors to always meet physically. Some may be at some different locations, and a video conferencing where they can come face to face via a camera and the network, that would be a valid provision of this section. So section 173 subsection 2 of the Companies Act 2013 will be read along with rule 3 and rule 4 again of the Companies Meeting of the Board and its Power, rule 2014. We discussed it in the very beginning that while we are doing the sections, we will be referring to the rules too. And you know why they have incorporated, why do we have to refer to rule 3 and rule 4? Why are these rules made? Because this is a new provision, and how to apply these provisions are given in the rule. So the directors can be present, they can discuss, and they can vote in a meeting, right? Either they can be there in person or via a video conferencing or any other audio-visual means, right? So their presence in the meeting would be valid if they are present via an audio-visual conferencing channel, right? And they can also discuss over that network and the camera, and their vote, if they are voting in such a meeting, that vote will also be valid, right? But the system of video conferencing or other audio-visual means that must be capable of recognizing the director. That means it must be clear, the picturization should be clear, and the other director sitting in the room or sitting somewhere else should very well be able to recognize the director by his identification number as well as the face that is being displayed on the video conferencing channel, right? And then that should also be capable of recording the meeting. The entire video should be recorded and stored, right? And they should be stored along with the date and time. So this is the minimum requirement of a video conferencing or an audio-visual conferencing channel, right? And the rule 3 also prescribes certain audio-visual means and the video conferencing channels, and only those would be valid. Only those are supposed to be used, right? As per the Companies Act, as per this provision of this section 173 subsection 2, and as per the rules. So the rules are basically framed to demonstrate them, to get a deeper insight. So the deeper insight says that yeah, there are certain video conferencing ways that we have listed, so please apply one of those, and those are very easily available. Now, the central government by a notification in the official gazette can also exempt certain matters from being conducted or being carried on in a video conferencing meeting. So let us try and see in detail what are the prohibitions on transacting certain matters by video conferencing or other audiovisual means. The first is that the central government is empowered, right? They can specify certain matters that yeah, these matters will not be considered or will not be conducted over the audiovisual means, right? And that will be done by a notification in official gazette, right? And along with that, the rule 4 will also demonstrate some of the matters that cannot be dealt on audiovisual means or video conferencing. Yeah, we are talking about rule 4 of the Companies Meeting of Board and its Power, rule 2014. Right? So now what are the types of transactions that are prohibited, that the rule 4 says that you are not allowed to do? So basically the very important decisions, right? You've always seen in certain cases the resolution by circulation is not valid. Why? Because they want that the gravity of the matter is intact. That if the matter is important, the board shall meet. They shall meet and discuss over the matter and then conclude. Right? So video conferencing is just a formality. But to show the essence and the importance of the topic, the meeting is the compulsion. So similarly, over here also, the video conferencing would not be entertained for certain matters. Let us discuss what they are. Like the matters like the approval of the annual financial statement. It is an annual financial statement of the company, right? The balance sheet, the P&L. That cannot be discussed over the video conferencing because you have to see them in front of you and you need to discuss, right? So it is an important matter. Rule 4 says you have to hold a meeting for that, a physical meeting, right? Then while approving the board report, that cannot be done by sitting at various places, right? A physical meeting is important for that too. Other examples are like approval of prospectus, meeting of the audit committee, right? And also approving certain matters, important matters, right? That can decide the fate of the company, like amalgamation, merger, demerger, acquisitions, takeovers. These matters cannot be discussed over video conferencing or audio-visual means, right? And otherwise, where other matters, they are allowed, and when the topic to be discussed in the board meeting is allowed to be conducted over the video conferencing or audiovisual channel, then the quorum, the members present via video conferencing for the meeting will also be included in the quorum, right? So I hope provisions of section 173 subsection 2 is clear with you. Now we move on to the next section, which is section 173 subsection 3, the notice of a board meeting. So when we talk about the notice of a meeting, what do we mean and why do we send a notice? Right? So the basic purpose of sending a notice of the board meeting is just to inform the directors about the time, date and place of the meeting. Right? You have to send them an information, right? So better for that information, send them a notice. So there is no particular form for notice that has been demonstrated. You can have any specific format, any format of your choice, and even an informal notice would be a sufficient compliance of this provision of this section. Right? So far as you abide by the other provisions of the section, like the notice of the meeting should be sent to the director at the registered address in not less than 7 days before the meeting. So 7 days period should be given to the directors to plan their presence in the meeting, right? And to plan over the topic that they are supposed to discuss if you are informing that in the meeting. Right? Because they know that okay, next Thursday we are going to have a meeting. Let us now prepare ourselves for that meeting. Let us be ready with our work, our end, and if there is a specific topic, let us be ready with the investigation and the points of that topic so that we can discuss it over in the meeting. So 7 days is the minimum that the Act says that you have to give. 7 days period has to be there. There has to be a 7 days gap between the notice and the meeting. Then section 173 also says that the notice must be in writing, right? So any oral communication either face to face or over the telephone will not be valid for this situation because it is not given in writing, right? But yeah, if you send the notice via a telegram or telex or a facsimile, that is fax, right? That is a valid notice because that is in a written format. So you can either get it hand delivered or you can send it by post or via email. All these things are handwritten, but you cannot give them a call or say face to face, okay, we are going to have a meeting. Oral is not allowed. And now we also need to see whom are we giving the notice. The directors, right? So which directors? So the Act says that the notice should be given to all the directors, right? Even if they are interested, that does not preclude you from sending them a notice. Maybe they are not allowed to vote for the motion or against the motion. They are not allowed to vote in the meeting, but still a notice will have to be given to them. They can attend the meeting, right? If there is an alternate director appointed, then you will have to send a notice to both the original director as well as the alternate director, right? And there can also be a case where the institute can ask you that Mr. X did not want to attend the meeting. He will not be attending the meeting and he requests the board that no notice should be sent to him because he will not be present at the time of the meeting. So will that be allowed? So the Act says that that will not be allowed. When the Act says that the notice has to go to all the director, means it will go to all the directors. There can be no waiver of the notice, even by the director himself, right? And when we say that the notice should be sent to the registered address, that means the address that the director has got it registered in the records of the company. The address where the director wants the communication to be made. That can be in India, that can be abroad. They never said that the registered address should be in India. We just said the registered address, wherever it be. It just has to be registered with the company, right? Now when we talk about notice of meeting, even an adjourned meeting is a meeting. So do we need to send a notice for an adjourned meeting? The answer is no. Because the adjourned meeting basically is the continuation of the same meeting. Right? Because some transactions were not being able to be concluded in the same meeting, so the meeting is adjourned for the next week, same day, same time, or whatever it is. Right? But yeah, there can be certain situations where you will have to send a notice for an adjourned meeting too. And there are two such situations. One, if your article says that you will have to send a notice for the adjourned meeting, then you will have to send. And the second, if the meeting is adjourned for some infinite period. You don't know when the next meeting will be held. So you will have to send a notice when the meeting will be held because the directors are not informed. You will need to inform them, right? That yes, this is the day, this is the time when we will be holding the meeting. So you will give them that information via a notice. Now, 7 days, yeah, that is the requirement of the Act. That is the requirement of the section. But that is not a compulsion all the time. Which means if there is an urgent business to be transacted, then a shorter notice for 3, 4, 5 days, whatever time you have, that can be given, right? Because there is something need to be decided in the 4th day and you haven't planned for it. That is an abrupt situation, for example, then you will have to call a meeting to discuss upon it. Now you will not wait for a 7-day gap, or you will not call a meeting 7 days hence after the matter is solved or after the condition is over, right? So for such urgent businesses, a shorter notice is also valid. But again, there is a condition for that. The condition is that an independent director should be present in the meeting. Otherwise, that will be invalid, right? Else, if the independent director is not being able to attend the meeting and then still you need to hold the meeting, then you can hold the meeting and the decision is circulated to all the directors, and at least one independent director should ratify that decision, and then it will be considered valid, right? But these decisions and these conditions will be applicable only to those companies who have an independent director. If you don't have, obviously you will not be able to comply with these provisions and this will not be applicable on them. Next you have the provisions of section 173, subsection 4 and subsection 5. So subsection 4 deals with penalty for default of notice. So if you are not giving a notice or you have not given a valid notice, that means you gave it for a shorter period of time and did not get it ratified, or you did not, there may be any other reason, like you may default in notice in any way. So if you default in notice, each director will have to bear a penalty of rupees 25,000. The defaults may be that the notice is not given under the authority of the company, right? Or it has been, you have given a contingent notice. These things are not allowed as per law, right? Now we had a pending subsection 5 that we had to discuss along with subsection 1, but we didn't. So we'll cover it over here. So subsection 5 deals with the notice in case of one-person company, small company and dormant company. Sorry, not a notice, the meeting, the number of meetings to be conducted. So the number of meetings for them would be just 2 meetings in a year, in a calendar year, right? That is the minimum. And in that case, 1 meeting should be conducted in each half of the calendar year. You had no such provision while you were discussing about the meetings in the normal company. You had to have 4 meetings, but 1 in each quarter was not a mandate. But over here, 1 in each half of the year is a mandate, right? And the gap between 2 meetings should not be less than 90 days. That means you cannot hold a meeting in June and the other meeting in July, and you say I have complied by the provisions and I have called both the meetings in different half of the years. No, because the gap is not less than 90 days, right? So that is the provision of section 173 subsection 5. So that will be all for the lecture today. We have completed the entire section 173 subsection 1, 2, 3, 4 and 5, right? So that will be end of the lecture today. We'll continue with the other subsequent section 174, 175 and the rest.